Австралийн хүмүүс ялгаа. Welcome.
Самбайцгааны хүн төгсөгчтэй. Өнөөдөр ороо манай департаментын төлөвийн зочноор Английн Лондон хотын олон улсын арбитражийн байгууллагын захиргаа хариуцсан ажилтан. Захиргааны регистрар буюу энэ бүртгэлийг хариуцсан захирал Сара Ланкастер оролцож байна.
Лондоны олон улсын арбитрын шүүхийн бүртгэлийн ажилтан, Лондон хот дахь олон улсын маргаан шийдвэрлэх төвийн ажилтан бөгөөд Лондоны олон улсын арбитрын шүүхэд мэдүүлсэх хэрэг маргаануудыг бүртгэх үүрэгтэй. 2012 оноос хойш Лондоны олон улсын арбитрын шүүхэд ажиллаж байна. Өмнө нь 14 жил Бекер энд Маккензи бүсийн Лондон, Сидней хот дахь салбарт ажилласан. Тэрээр эрчим хүч нөөц цахилгаан холбоо, мэдээллийн технологийн салбарын маргааны шийдвэрлэх чиглэлээр мэргэжсэн. Ноттинхэмийн сургуулийг хуульч мэргэжлээр төгссөн, Лондоны Кингс коллежид мастер зэрэг хамгаалсан. Англи, Уэльс, Австралид хуульч мэргэжлээр ажиллах зөвшөөрөлтэй.
Good evening.
Good evening.
Very nice to meet you here in London.
And you as well.
In Mongolia, we always, particularly in the business sector, always have a question. Why would two companies in the world suddenly will refer to London for case of disputes? What do you think about that?
It's a very good question. Arbitration is an option that's very good for parties where you have two companies from different countries. Primarily the reason parties decide to choose arbitration rather than going to the courts is for enforcement reasons. So for example, if you had a Mongolian company and a French company who entered into an agreement, you might have trouble enforcing a French court judgment in Mongolia, or you might have trouble enforcing a Mongolian court judgment in France. But if you provided for arbitration, then as a result of something called the New York Convention, enforcement of arbitration awards is much, much easier globally than court judgments. Why, for example, a Mongolian and a French party might choose London could be for neutrality. Very often when you have companies from different legal backgrounds, different cultures, they're a little bit nervous about agreeing to the country of the other as the place to resolve the dispute. So they want somewhere that's a bit more neutral, a third country. So they might pick England for that reason. And arbitration has a big advantage over the courts as well as enforcement. It has the advantage that it provides a more neutral forum. So arbitration incorporates some elements of the civil law system, some elements of the common law system. So
Before it goes to criminal.
Well, yes, the sort of the civil, I mean, in the sense of the legal tradition. So, for example, France is a civil law country. England is traditionally a common law. So, rather than a lot of things being codified, we have, for example, cases and precedents, and it combines both of those things. So, it's a bit more of a familiar and neutral process for parties from those different countries, and we sort of at the LCIA help to administer arbitrations, and parties can choose our rules to decide how their disputes will be determined.
So what you're saying is before disputes comes in businesses,
Yeah.
before they go to the court where the decisions will be enforceable, right? They go to try to solve the disputes at another level before the court, which is arbitration.
Arbitration is a little bit different. What you're talking about probably is more mediation. So mediation would be something you would do as a preliminary step, either before arbitration or before the courts. And the LCIA, actually, we do have a set of mediation rules as well. Arbitration is an alternative to litigation. So generally in their contract, parties will either say courts or they'll say arbitration. So arbitration isn't a preliminary step before the courts, it's a complete alternative. So if you go to arbitration, that is where your dispute will be resolved instead of in the courts.
And the decision of arbitration will be enforceable?
Enforceable more easily, very often, than a court judgment.
Well, you said more easily. Why more easily?
More easily because with court judgments, the way that it works for enforcement in other countries abroad is you will only be able to enforce very quickly and easily in the courts of a foreign jurisdiction if there is a convention or a bilateral agreement between those countries. So for example, within the EU, you have got easy enforcement of, for example, an English court judgment in France or a French court judgment in Italy or Germany because there are European regulations in place. But if you go outside of the EU, for example, I've spent a little bit of time working in Australia, and it's not necessarily easy to enforce an English court judgment in Australia. Arbitration awards, there is a separate regime. There's a big worldwide convention called the New York Convention that most countries in the world, including Mongolia, have signed up to.
New York Convention.
Indeed, the New York Convention of 1958. And what that says is where you have an arbitration award, the courts, for example in Mongolia, will enforce an arbitration award that has been made in London.
But by the signatory countries.
Indeed.
Wherever it is.
Indeed.
You said about the common and
civil law
systems. Please tell to our audience what's the principal difference of them, because it's causes a lot of confusion.
Yeah.
In Mongolia we have both systems.
In Scotland they have both as well.
Okay.
There are a number of differences. What it really means, for example, in an arbitration or a court context, so sort of once you get to that point where there's a dispute, traditionally in civil law countries, you don't have very much document production when there's a dispute. So for example, documents relating to the entry of the agreement, documents relating to the supply of the goods. In England and in the US, for example, which are common law jurisdictions, you have something called disclosure, or in the US, discovery. And what that means is there's an obligation in court proceedings on a party to provide copies of all documents that are relevant to the issues in dispute. So for a party, for example, from Japan or from France, where it's very much a civil law jurisdiction, they won't be used to a proceeding where suddenly there's lots of documents.
How you could solve the issue without the original document?
Well, some documents still need to be produced, but it's a question of volume. And witnesses is another issue. In civil law tradition, very often you don't have lengthy witness statements. You won't have cross-examination of witnesses. You might have questions posed by a judge. Whereas, for example, in the English courts, there is a tradition of written witness statements, and there is then a tradition of cross-examination. So if you were there to give evidence on behalf of another party, I was acting for the other party, I'd get to ask you lots of questions rather than the judge. Arbitration offers a bit of a hybrid between those two systems. So it has much more flexibility in terms of how documents are addressed, how witness evidence is addressed, and that's why it offers that slightly more neutral forum where you've got parties from different backgrounds.
And yet common also sort of, you consider similar cases, solutions before that case. You consider also historically what was the decisions in similar cases, right?
Yes.
And it will be more based on that, how the problem is solved, or?
Well, in arbitration, there's a number of different factors that will influence how an arbitration is handled. One of them is the identity of the arbitrator. So in arbitration proceedings, parties have more control over the identity of the arbitrator. In the court system, they have a judge usually imposed on them in a case. They don't get to pick which judge they want. In arbitration, parties can agree. So the identity of your arbitrator and your arbitrator's legal background might influence how things are addressed. The other issues that will influence are the governing law of the contract. So for example, even if the seat of the arbitration is in London, the governing law of the contract might be Chinese law. So there will be an influence from there.
So what will happen then? How you can do the case here when the whole thing is to be enforced by Chinese law?
Well,
Or about Mongolia law?
that's the beauty of arbitration. The seat of the arbitration and the governing law don't need to be the same. So if it were a dispute where the seat was London but the governing law of the contract was Chinese law, then if the arbitration were to come to the LCIA, we would obviously look to find an arbitrator, to help the parties find an arbitrator who is experienced in Chinese law, because that is the law governing the contract and the substance of the parties' dispute.
Speaking about London.
Yes.
Or the so special that everybody is referring to. Tell us about the history. How come to this level?
Yeah, it's a very good question, and the LCIA is one of the oldest and one of the world's leading arbitration institutions. It's been around since the late 1900s. It originally evolved on a more domestic level when parties were dissatisfied with how slow English court proceedings were. So it evolved out of that dissatisfaction. But nowadays it's completely independent, company limited by guarantee, and it sort of has built over the years and very much grown into a more international institution. We have, for example, last year there were 265 referrals to us for arbitration. Of the parties involved in those cases, only 16% were UK parties, and the other 84% were parties from elsewhere around the world, and a very good spread of Asia Pacific, Africa, North America, elsewhere in Europe. So a really broad spread of parties. I think there's still a number of jurisdictions that very much look at England and the English courts as a very good system. I mean, the English law has developed well over the years and is seen by parties as a very strong neutral law to adopt for their contracts. They might decide to have the seat of their arbitration in London. The relevance of the seat, which is a bit of a technical term in an arbitration context, the seat of the arbitration will be, if there are any problems as the arbitration progresses, generally you go to the courts of the seat to have those problems addressed. So, for example, if there's a challenge to an arbitrator, ultimately you would go to the courts of the seat. So parties look at the English courts and say, the English courts are very good, we'd like to choose LCI rules. Maybe we'll choose the seat in London because then we've got the English courts. But we can, at the LCIA, because of our international nature, we can administer arbitrations anywhere in the world, and we do in fact have at the moment, for example, I know recently we had one request for arbitration where the seat of the arbitration is over in Hawaii. So we do administer arbitrations really anywhere in the world.
Who are those judges working for you? Are they independent ones, or they are full-time your employees, or how does it work?
No, they're actually completely independent. So they're not employed by us, they don't work for us. Many arbitral institutions have sort of a formal list of arbitrators which they might, for example, publish on their website. At the LCI, no, we don't. I was going to say we do something slightly different. At the LCI, we have a very extensive database of neutrals who are arbitrators, mediators, experts. When we receive a request for arbitration, we'll look at the clause. If the parties have agreed that they will each nominate an arbitrator, then we wait for them to provide their nominations.
Whatever country they are from.
Indeed.
And they come here to the discussions here?
It depends. Very often what we find, because you have got parties from different countries, the cost involved in travelling is slightly prohibitive. So it will depend on the particular tribunal once they've been appointed. Usually the initial hearing might be held in person for half a day, or it might be done by way of telephone conference, very occasionally video conference, but then normally the final hearing where witnesses are present and legal arguments are made will be in person.
List of professionals who had practices in that particular field of litigation, or?
Yeah, so we have this big database which contains huge details with identity of people, the languages they speak, the various legal jurisdictions they're qualified in, which areas of expertise they have. So, for example, for Mongolia, I know there's sort of very strong developing mining industry,
Yes.
so we have sort of details of people who've got real expertise in mining. And what we do is we filter through that and we find someone who is suited and appropriate, has the right skills to be an arbitrator for that case. And the LCA court will then, once they've selected a candidate, appoint the candidate, and we inform the
Who
parties.
is on the board of the organisation?
Well, the board's something slightly different. So we have a court and a board. The court are the ones who assist with the appointment of tribunals, deal with any challenges, make sure that the costs of the arbitration are controlled. The board runs the company, the sort of business side of the LCA. So they don't really get involved with the actual cases themselves. And on the court we have a huge number, a fair number of very eminent practitioners from all around the world. We've got, our current president is Professor William Park from the US. We've got vice presidents from India, from Canada. We've got a New Zealand vice president.
Japanese?
We've got, indeed. So we've got a complete range of different jurisdictions around the world on the court, and that's important for us with the international profile of the cases that are referred to us, to have very good practitioners from those countries that we can refer questions to.
Well, now I have another sort of questions, because the job what you do, which is quite important for businesses all around the world.
Yes.
What does it take to be a judge at your organisation?
To be an arbitrator, that's a really good question. And it's one that I get asked quite a lot by practitioners, is how do I get involved? Most of the arbitrators we have in our database are people who have, during their earlier careers, been involved as counsel in international arbitration. So they're generally legal practitioners who've built up a lot of experience in arbitration. And in particular industries, say telecoms or energy and resources or construction. But from countries, again, jurisdictions all around the world. What we do is, if the LCI court selects someone who hasn't been appointed as an arbitrator before, usually they're selected as one on a panel of 3 tribunal members, so that they sort of have a gentle introduction rather than being thrown in straight away. So, we very much take steps to make sure that they have the appropriate tribunal. Yes, so a tribunal can either be 1 arbitrator or 3 arbitrators, occasionally more, but the most common is 1 or 3.
And depending on what?
It depends on what the parties have put in their arbitration agreement.
I see.
Usually parties might decide for 3 rather than 1 if they think it's going to be a very complex or high value claim, or if it's going to be a very technical claim and they think, for example, it might be useful to have a lawyer but also a technical expert on the tribunal, because although I said most of the individuals in our database are lawyers, we've also got accountants and people from other backgrounds. For example, chartered surveyors. There's quite a few people come up through the chartered surveyor or the construction industry who've qualified as arbitrators, and they might, rather than having had that experience in practice, they might have done courses to train as an arbitrator.
So in case, for example, of course I understand every case are confidential at the arbitration court.
Yes.
But a government, national government, a sovereign government comes and they have a dispute, say, with the transnational company.
Yep.
Would they also agree in the agreement how many tribunals to be there, etc.?
That's right, they would normally agree. So in an ideal world, at the point where a company enters into a contract with another foreign company, they should try and make sure they get the right clause in their agreement at that point.
Which would be what?
Well, if it's an international contract, I would say it should be arbitration. Because I'm with the LCA, of course, I'd say it should be LCA, but there are a number of very good by the rules.
So this document about arbitration rules of London Arbitration Court, knowing these conditions, people are fair to your organisation in case of disputes, right?
Yes.
How often do you update this?
That's a good question, because you can see from the front that that version is 1998. And a lot of the arbitration institutions like the ICC, the Singapore International Arbitration Centre, have recently been updating their rules. We actually started a review of our rules a few years ago now. And the revised draft of the rules is at a very advanced stage. So we're hopeful that the new version of the rules should be out later on this year.
Previously, and you have been working with the cases in the resources.
Yes, that's right.
In the resource disputes, and I mean, what would be the common, say, cases that bring the people to arbitration that the parties could avoid?
Yeah, that's a very good question. I mean, I think that the ones that the parties can probably avoid is there are always a number of disputes between parties as to what a certain provision in the contract means, because it's not very clearly drafted.
Yes.
So companies, you know, the primary focus really is taking the time and money to make sure the contract is clear and that both parties understand what it says.
Same understanding on this provision.
That's true. Other disputes that sort of very often come up are the old ones about, you know, actually one party realises it can't perform. For example, it can't provide the quality of the product it had agreed to provide, and therefore there's a dispute about that. Or one party getting into financial difficulty, finding it can't pay the amounts due under the contract. The party that provided the goods or services.
New emerging economies, new governments, developing countries which usually have not that deep experiences in mining, say, contract businesses with the transnational company, which has extended experience and they know what clause is mean or doesn't mean what. They know well, and in that case, is it particularly advisable to have a lawyer for that, the new government, new emerging nations government, or what is the best?
Yeah, I mean, certainly my experience when I was a lawyer in private practice, I think it is worth companies spending the time and the money to get lawyers involved if needs be, to make sure the contract is right at the outset. Only because if you do get into a dispute, whether it be the courts or whether it be arbitration, it is going to be an expensive process. You know, our costs, as I mentioned earlier, we're a not-for-profit, the LCIA, and our administration costs are very reasonable. The costs of the arbitrators are also very reasonable. They're capped at an hourly rate of £450 an hour by our schedule of costs. But obviously the parties' lawyers' fees in arguing, fighting a dispute can be very significant. So it's worth spending that lesser money at the outset when you're agreeing the contract to make sure that it's all right.
£450 an hour fee of the arbitration process, or it is before the contract is done?
No, sorry. So that's for the arbitration process.
Arbitration process.
So your lawyer's fees at the point where you're negotiating the contract will be what you can agree. And a good point that comes out of that is, of course, the cultural issues, because where you have got parties from different jurisdictions, they might have different expectations or assumptions. So it's making sure you understand each other's cultural background to make sure that there's not problems in interpretation that could result from that.
Well, there would be many. I think it will take a long time to get different jurisdictions understand the same thing in the same way.
Yeah.
Do you, I mean, how you become a lawyer? Was it difficult to be a lawyer here? Do you have particular license, or how does it work in the UK?
There's several different routes actually in the UK. The route I took is the traditional one. So I did an undergraduate law degree. My law degree was 4 years because I spent a year at university in Germany as well. I then did a 1-year practical course called the legal practice course, which gave me sort of more skills to prepare me for working as a lawyer in private practice. And then I did a 2-year training contract with a firm where you spend time in a number of different departments and you get on the job training to be a lawyer. So it was a 7-year process in total.
There.
Yeah, there are certain skills you do have to
And
cover.
you specify by lessons for that.
That's right. So you get what's called a practice. Well, you get your admission certificate, and then you have a practicing certificate that you need to renew every year in order to be able to practice as a lawyer.
You need to renew every year.
Yes, your
Who will
practicing
renew?
certificate.
Who?
Oh, the Law Society.
The Law
If you're a lawyer in
Yes.
England and Wales, the Law Society.
You must be a member of Law Society.
Yes.
Wow. So how many of them are here?
Oh, thousands and thousands.
In every city may have own law society?
No, in England there's just one Law Society of England and Wales, which are headquartered here in London.
Yeah, meaning the thousands, you mean every city may have the society or part of that society, or how does it work?
Yeah, there'll be lawyers in most cities in the UK.
So they renew your license every year?
Yeah.
What?
So we don't have to do tests to renew it. It's not like
Okay.
it's not like your driving license
Okay.
where you have to go and do the test every year.
How do you go through
It's-
that? Why are they?
No, you pay them money,
Okay.
and you confirm that you
not
have done your effectively continuing legal education. So there's sort of a certain number of training hours
Yes.
that you need to have completed
I see.
in a
Every
number
year.
of different areas
Every
every year or every 3 years,
Well,
depending on how
that's
senior
very
you are.
important. That's what, because some sectors keep developing so fast.
Yeah.
And now technology comes in telecommunication, confidentiality issues different.
Yeah.
way. So you, as a lawyer, have to go through these trainings to be renewed.
That's right, and you'll find that most law firms in London actually have, and elsewhere in the UK, actually have their own training programs. So most firms will do more training than the minimum training requirements, simply because, as you say, the law develops so rapidly. So there is a significant amount of training undertaken in this country.
And every law firm sort of obliged or sort of proactive having their lawyers getting trained in particular
Yes.
sector. And the law society sort of, they know what kind of trainings to be done.
That's right, that's right. So for example, in an arbitration context, the LCIA has a number of seminars, or symposia as we call them, every year. We always have at least 2 in England. And then we have sort of a cycle of conferences around the world. So Adrian Winstanley, our Director General, is currently on his way over to Toronto because there's a symposium at the end of this week. So far this year we've had one in Colombia, one in Lagos, one in Doha over in Qatar.
And
so there's a sort of real program of education there.
So those are open also for Mongolian lawyers?
Absolutely. So there is a charge for the LCIA symposia. Sort of the list of all the different dates and venues are available on our website.
What is the best way for Mongolian lawyers to be in this network, to be members of what, and how do they get the information?
There are a number of different ways. You know, as I said, sort of the LCIA, we have our conference agenda for the year. We also have a regular newsletter and a publication called Arbitration International, which we send out to lawyers who are members of the LCIA, and details sort of about membership are on our website. A number of the other arbitral institutions have similar programs of conferences that take place in different places around the world. For example, I know the Chartered Institute of Arbitrators held their Asia Pacific conference in Sydney in May last year, because I was working in Australia at the time, and I went to that one. For the younger practitioners, there are things like YIAG, which is the LCIA's Young International Arbitration Group. It's aimed at practitioners who are aged up to 40. And there are symposia, which are obviously at more cost-effective rate, organised for them. There's discussion forums, and there are other organisations, for example, AFIA, the Australasian Forum for International Arbitration, which again is for younger practitioners. Membership is free. They organise symposia around
that's
the
good
region.
Information for young lawyers.
So yes, so that there are a lot of ways out there to get involved.
Last question about
Yes.
Mongolia. Do you have files with Mongolia?
I had a quick look at the system actually
Okay.
before I came to meet you. At the moment we don't have any arbitrations with Mongolian parties, but we have had arbitrations in the past with Mongolian parties. Unfortunately, because of the confidentiality surrounding. I had a quick look at the system actually before I came to meet you. At the moment, we don't have any arbitrations with Mongolian parties, but we have had arbitrations in the past with Mongolian parties. Unfortunately, because of the confidentiality surrounding arbitration, I can't provide any details. But yes, we have had Mongolian parties.
On one side, I want Mongolian lawyers to learn more. On the other side, of course, it's better to have less cases here.
Yes, better to have less cases at all and have contracts go off without problem.
You know, what you said, very important for new emerging nations like Mongolia, in particular at this time when we are trying to get out as much as possible from mining industry and to invest all this into the other sectors, and the particular your ideas about the current situation, the way how you solve problems, how you make the business better is very important, and I thank you very much for having coming to the show and sharing your thoughts with us.
Well, thank you very much for letting me come meet you.
Thank you.